Hello and welcome to another question and answer session with industry thought leaders. This time we have the privilege here at Nicopure Labs to having Charles Hamshaw-Thomas, the head of legal and corporate affairs for Europe for Nicopure Labs, visiting us here in Trinity. As always, I'm Patricia Kovacevic, General Counsel and Chief Compliance Officer for Nicopure Labs. Today we are going to talk about the Tobacco Products Directive implementation, its status, and its implications for the industry. Charles comes to us from the industry. He has extensive history and experience, both as an attorney in the United Kingdom as well as in the nicotine industry for a very long time. And in fact, he was part of a very successful early adopter of vaping products in that market in the UK. The UK continues to be a very important market, of course, for all of us, in particular in light of the fact that the UK government is communicating comparative harm and benefits of vaping products compared to conventional cigarettes, which is something that we don't see here in the US. So, Charles, could you please tell us a little bit what is the status of Tobacco Products Directive implementation in Europe? We're approaching November 20th, which is an important deadline for the industry. And what does that really mean, where we're at, and what is industry looking to in terms of this deadline?
Well, I think Nicopure Labs, where we're at, like I'm sure a very large number of the rest of the industry, are all hands to the pump in terms of the very large workload that is necessary to meet the November 2016 and May 27 timetable. Now, I say those dates, obviously not all member states have transposed the TPD with such speed as the UK has done, but that is the current timetable. And obviously, the immediate focus is a lot of work, almost IT overload with the work being done on the notification process, and then enormous amounts of work being done in terms of production scheduling and inventory management for the purposes of the labelling requirements.
And also the size of the bottles goes down from anything to 10 ml, which is now the maximum allowed, correct?
Absolutely, absolutely. The labeling requirements, the product requirements, and so forth. I think it is important to note. I mean, I think there are some challenges which I'd be very keen to share with you. I think that the first and most important point to note is that the Article 20 brings the clarity and certainty to the regulation of our products, which there hasn't been for a while, and I think that's very, very important. And I think that's going to, there are parts of Article 20 which are very, very important and undoubtedly are going to improve the marketplace. It's going to improve consumer confidence in the products. And why do I say that? I say that because the costs and other requirements of participation in the market are going to increase. That might lead to consolidation. It might lead to some people leaving the market and so forth. I think the established products, brands are going to become the even more established, the reliable sellers and so forth. It's going to have a big effect, but that's not going to happen overnight because there is a period of time up until obviously nothing's really going to change, arguably until May of next year. But I think that we at Nicopure Labs obviously pride ourselves in doing absolutely everything in the right, best possible, optimum way as soon as possible, so that we can give all of our customers absolute confidence and assurance regarding our products and the future growth of the category.
So some of the positives of the Article 20 would be, for instance, the requirement to disclose ingredients to the various member states, which arguably gives some confidence into basically the information about the product. The obligation to have a leaflet with instructions for consumers, correct? That would basically give the consumer some guidance as to how to use the product. And last but not least, of course, the health warnings, whether we agree with them or not, but certainly it is a means to communicate with consumers.
I think all of those things that you've mentioned are absolutely right in terms of providing adequate, appropriate information regarding our products. I think what is of more concern, and I think what the transposition process has highlighted, are some of the continuing difficulties that we're going to have and some of the continuing anomalies that there are with Article 20. In the UK, and perhaps I can just go back to that for a minute, because I think in the UK we're extremely fortunate with our UK operation, because the regulatory body in the UK, the anointed regulatory body, the MHRA, the Medicines and Healthcare Regulatory Agency, in line with the UK government's support and endorsement of harm reduction and vaping products, has taken a very pragmatic, constructive approach in terms of the transposition of Article 20 and the implementation. There's very good dialogue going on there. It bodes well for the future of vaping and the vaping industry in the UK, and we very much hope it can serve as a template for member states across Europe, and indeed, why not further afield? It is pragmatic. Having said all of that, there continue to be some anomalies, and those are the ones we need to continue talking with government, talking with the MHRA, talking with all of the interested stakeholders about. For me, some of those anomalies are the advertising ban, which for products which, as the Public Health England, the Royal College of Physicians have announced, are at least 95% safer than the products they're designed as an alternative for. It doesn't really make a lot of sense that there should be effectively an advertising ban on those products. How do we make them raise awareness of the availability of these products with the benefits that they have in terms of the smokers that are out there?
So just to give our audience a flavor, the UK has various advertising bans that are not as strict as other countries. So in the UK, you can still have outdoors advertising, you can still have point-of-sale advertising for vaping products. In France, for instance, just to give an example, the only advertising that is really permitted for vaping products, and France is a very important market for us with the product Halo. Of course, we're present in the UK with Purity. So in France, the only advertising you can have is a point-of-sale display that is not visible from the outside, which really limits your communication to merely those consumers that actually set foot in a vape shop. Already, if you were to sell your products in France through, let's say, a conventional newspaper kiosk, that newspaper kiosk couldn't have any advertising, because that advertising in France would be visible from the outside and therefore in violation of the advertising ban. So indeed the UK, I mean, it sounds like it's very restrictive, but it's even more permissible than other countries. And some countries, my understanding is, have gone as far as actually banning advertising altogether, including point of sale.
Yeah.
So that is absolutely true.
I agree, and there are some anomalies there, Patricia, that as an industry we need to be working through. And I'd like to see this happen across the industry with member state governments, with people in Brussels and all around the patch, because it is a seismic point that the Public Health England and the Royal College of Physicians have raised. Our products have a role to play in terms of the public health agenda going forward. And the industry must, obviously, we must communicate responsibly regarding our products and the information that goes with them. But for that to be turned into an advertising ban, it is something we've quite clearly got to, as I've said, work through with governments and regulators on. I think there's some other anomalies. The product limitation, the product specifications that you mentioned, the 10 ml refill bottle. You will only be able to sell our product in small quantities, and that is an anomaly. The 30 ml bottle has been the dominant product form factor in the market for several years. Now, regulators only want us to sell in small quantities. Now, a product that's safer than the alternative to which it's being sold for, you can only buy it in smaller quantities, whereas the more dangerous product that we're sold, there's a restriction in the same Tobacco Products Directive that cigarettes can only now be sold. They can't be sold in small quantities. You can only buy them in bigger quantities. That is a logic and there is an absence of logic and rationale in that, and I think that's the sort of thing. If it's agreed, and I think it is agreed in the UK, that vaping products have a role to play, do we not want to see those being encouraged and helped relative to the more dangerous products that they're there to replace? And building a brand on a 10 milliliter bottle, it's going to be more difficult, particularly when there's more information that needs to be on it and the packaging. You've got a smaller space to put more information on. So it is counterintuitive. It's not helpful for us as an industry, for the suppliers. It's not particularly consumer friendly. It's not particularly environmentally friendly. So there's these sorts of things that I think we do need to work through. The third one, which I think is actually something that we feel the UK are and intend to take a much more pragmatic approach on, is the 6-month notification process. Our market has grown very, very quickly over the last few years. The evolution of the technology and the innovation has been incredibly rapid. We're seeing products that are, within 6 months, they've almost moved on to the next stage. It doesn't really make sense to say you cannot put a product on the market until it's been there, until 6 months have elapsed. I think we're hearing in the UK that there's going to be a much more pragmatic approach there, and quite clearly it links to the work the industry very much needs to do in terms of the standardization of our products. Our products are recognised as being 95% safer than, at least 95% safer than cigarettes. If we have some standardisation, we can be certain that all the products that are going on the market are of that level. Why would you want to hold any of those back if they're 95% safer? And there's also a lot of innovation going on. I think we're going to be seeing some products that are a whole lot better than that as well. So, there are some issues, and we need to. In our view in the UK, we think that these anomalies that I've just mentioned illustrate the fact that Article 20 still doesn't make a lot of sense, not a lot of common sense in terms of the public health benefits. They're bad news for parts of Article 20 are bad news for public health. I think parts of Article 20 are better news for those selling combustible tobacco products than those like us that are selling vaping products and other reduced risk products.
Indeed, I was going to ask you who benefits from Article 20, because obviously there is a clear benefit to someone.
Well, I think there is a benefit to the people that we're competing against, which are the suppliers of combustible tobacco products. One would like to hope that that's an error. And it's something that they didn't necessarily, unwittingly have done. And I think the third point is a slightly political angle on it. But there are, as people know, there are a lot of people in the UK who've been talking about ill-conceived regulations coming from Brussels, and they will be pointing to these as examples of ill-conceived regulation. And with the continuing attention that the whole Brexit issue has, I think it is an example of the fact that this is far from perfect, and I think we at Nicopure will be doing our best to make sure that there is wider awareness of these difficult issues, and anybody who's got an interest in reducing tobacco consumption, reducing smoking, tobacco harm reduction generally, should have an interest in making sure that there is this wider awareness of these problems.
So speaking of Brexit, now that you brought this up, I'm going to spring a question on you that is completely unexpected. For our viewers here in the US, clearly, it's not entirely clear what the process for splitting up from the European Union is. Can you give us a little flavor? There was a court case recently that argued, when this whole process can take place. A little bit of background on that, if possible, as to when and how it's likely to happen, and what are the legal steps, more or less, in a few words, that might
Well, I
be
suppose
required.
at times I might like to think I know a lot about a lot of things, but the political machinations are an area of interest to me. I wouldn't necessarily profess to have expertise on it. The implications of Brexit and the vote of the referendum in June of this year are momentous from a political point of view, in terms of the decision being that the majority of the UK population wish that the EU, the UK are no longer members of the European Union. The detail of how that is processed and how that is gone about is quite complicated. It is still, it's not been done before, and so there's a lot to be worked through.
It's my understanding
Legally,
that the Parliament needs to initiate it.
Legally, the process is that a 2-year gun needs to be fired, in which case you announce that you're triggering the negotiation process with the European Commission, and that has that gun has not been fired yet. There are some people who'd like it to be fired now. There are some people who'd like to delay it until there's more certainty as to how we're going to go about it. And there are still a lot of people in the UK who are very concerned about the decision in the referendum, and they have made an application to the court to get a ruling that actually that gun cannot be fired until such time as Parliament, that is the UK Parliament, has approved it. I suppose some might regard it as an attempt to sort of row back on Brexit. I don't think that will happen, because the politicians will, they have to accept the mandate of the people. So we are talking about the exact process upon which we leave. And so what will happen? Well, the gun will get fired at some point, and a vote will have to be taken in Parliament. It's a fine judgment call as regards when the Prime Minister decides that she does that. But I do think, as I've said earlier, that this process about the UK leaving Brussels, there's already every single industry, I say every single, lots and lots of industries are already talking closely with the UK government and the relevant government departments about the implications of Brexit for their industry. And I think it's very, very important that the vaping industry is in there in the same way the other industries are in there, talking about the implications and so forth of that exit process. And
So
Nicopure Labs, we intend to be absolutely at the forefront of that. For the reasons I've outlined, there are a lot of quite difficult issues that need to be worked through.
So for a company such as ours, who really wants to have a pan-European presence and does have a pan-European presence, but has a legal entity presence in the UK, we're looking at least another 2 years where clearly the contiguous market of the EU will remain united, clearly, because this 2-year period hasn't been triggered yet. But more importantly, going back to the TPD, baffles the mind how in a united Europe, Brexit aside, really the TPD does not allow any kind of advertising that has cross-border effect. So it's very difficult to build a brand in an European context, if you wish, in more countries, if you really cannot communicate that brand across border in communications such as advertising, perhaps surrounding conferences or any other events that may be televised in more than one EU country. So what do you make of that? Why do you think that is? I mean, it's a product that ultimately, there should be free circulation of goods. Ultimately, the product, if it's available in one market, should be available in another one, and so on.
Well, I think I probably would take you back to the UK approach, and the UK was very, very prominent in the debate in 2013 and 2014 in Brussels, and the development of the Tobacco Products Directive in terms of the Article 20. And I think that the UK response and the UK position has been very, very different from other member states, as I've outlined, and the the UK government and Department of Health and the MHRA have shown and continuing to show endorsement and support for tobacco harm reduction and vaping products. Now, there wasn't that level of support for vaping products as an alternative to combustible tobacco products in 2013 and 2014. It was only in I must get my years right, but it was only in 2015 that Public Health England and the Royal College of Physicians, with their reports and their findings, it now seems to be very, very widely recognised that our products have a role to play, and there are benefits there. Now, that hasn't been widely recognised in Brussels. The UK, we may not be the most popular people in Brussels in terms of the politics of Brexit. There are other member states who have taken, almost similar approach, and I think the French are taking quite a positive approach towards vaping products. And I would urge that, as an industry, we do our best to make sure that, where the UK are at on this, are they right? Are they wrong? What are they learning from it? What are we seeing in terms of the consumption of tobacco and smoking levels in the UK as against the development of the vaping products? And I think there's a lot we could show. There's an obvious analogy with smokeless products that have been banned in across the EU, but are allowed in some member states because of particular derogations given previously. Obviously, we're not at that stage now with vaping products, but I think we should continue to work very, very hard to make sure that there is a consensus view in Brussels about the role of vaping products. And we still have this position that some member states want to see particularly onerous restrictions on vaping products in comparison to others. You've mentioned advertising. There's other areas as well where people are taking a more severe interpretation. And
for instance, the cost of pre-market notification in some countries such as Denmark is as much as 4,500 euros per application, which for most small companies is basically unsustainable.
yes, and that of itself would lead one. It wouldn't be unreasonable to make the conclusion from that they're not particularly keen, desirous of seeing reduced risk products being promoted or entering that market. But I think the UK, take a different example, if vaping products can reduce the amount of smoking and tobacco consumption, their wider use availability should be encouraged rather than restricted.
That all sounds indeed like a very good characterization of where we're at with TPD. Thank you very much, Charles. We will for sure speak again in about 6 months' time when May 2017 will have come, and then we can probably see some events of enforcement, certainly in Europe. Thank you very much for your time, and we hope you enjoy your stay in Trinity.
My pleasure. Thank you very much.
And we are looking forward to meeting you during our future webinars. Thank you as always for your attention. Goodbye.